I like to reward those people that show up on time. I'm sure some other people are going to show up, but why don't we kind of get going, get started? For those of you that don't know me, I'm Rick Martin. I'm with Fortress Federation Investments. Um, we currently sponsor in over 1,400 units in the southeast in Texas. We primarily focus on value add. If you blend in my passive investments, I'm in over 2,400 units. So if you're looking to passively invest, I did put my Calendly link in the chat. Reach out. We can have a talk if you wish. Um, but what we really want to do is get to tonight's featured guest, the star, Mr. Nick Moore, has been kind enough to join us tonight. Um, a few things about Nick. He's a partner in real estate and private equity practice group at Robinson and Franzman LLP. Could be Robinson, Franzman, and more in the near future. I told him I like the ring of that. Um, he handles virtually all transactions involving income producing commercial real estate. He represents owners, investors, general partners, and limited partners alike. Nick's clients are focused predominantly on the national multifamily real estate industry, as he has transacted hundreds of millions of dollars in commercial real estate. Nick has been selected as the Georgia SuperLawyer, which I want to ask you about, as a rising star for the years 2021 and 2022. This exceptional award is provided to the top 2.5% of vote earners for the area of business and corporate. Yeah, Nick, I wanted to ask you what is a Georgia SuperLawyer?
It's probably a dubious honor that just sounds cool. Instead of just being a regular lawyer, of course, I'm dubbed super. A great superlative. Look, there's not a lot of accolades really that you get in this profession, and so I think it's Walters Kluwer or one of the other kind of major publishers. They Sorry, I'm next to I don't know if you can hear the background noise.
Oh,
I've got two
just
small kids, so if it comes through, we just gotta roll with it. Um,
we might have to combat in that regard. I got like a screaming little 3-year-old myself,
yeah,
so
we were
should be
talking
fun.
about that, man. Yeah, nothing but love. But yeah, so it's actually a peer voted award, and so you get on the program, the forum, and somebody nominates you, third party, and then other attorneys, just kind of vote on the quality, typically based on interaction and other things. That just, I guess, just distinguish you from some others. And it's really a marketing thing more than anything, because there's no judges or anything, but just know that it's just that I guess I've apparently been well received by my peers in the industry, which is terrific. So uh, you know um,
Yeah, well,
the opinions that I hold closest are my clients, but it's great to have that the industry recognize my hard work and ability.
absolutely, man. Yeah, you got a great reputation out there. That's why I got a hold of you. Wanted to hold this tonight. Just to let you guys know, we're gonna keep this mostly interactive. We don't really have like a PowerPoint presentation. I'm gonna ask a few questions. We're gonna talk a little bit, and then open up to you guys. So hopefully you guys brought some questions. Um,
Yeah, drop them in the chat box or whatever, what feature we have. I love to know that I'm speaking intentionally to some of you, and I know that access to attorneys like myself can be rare, particularly where you're not forking out a bunch of money up front. So
it's a good
if
deal.
something's weighing on you, I'm giving hypotheticals. Rick, if I might do my quick disclaimer, obviously this stuff's hypothetical and meant for academic purposes, but if I'm able to educate you in such a way that you feel more confident than you did before, that's terrific. But certainly feel free to reach out, and my contact info will be available to you to speak more particularly, and then you can just rely all on the advice I give you at that
Yeah.
point.
Actually, I already hooked you up with a colleague of mine. He says he's saying high things about you already. So if you folks have legal needs, definitely reach out to him. I did put Nick's contact info right at the top of the chat. Um, So people are still coming in. I'm going to be looking back and forth between questions and trying to admit people into the room. But let's start with kind of what I talked about on the flyer, and that's the PPM. You know, a lot of passive investors, especially first-time passive investors, and actually active investors who
For sure.
invest passively on the side, including myself. You'll engage in a lot of due diligence. If you're really doing your homework, you're analyzing the submarket, you're vetting the operator, and you're vetting that deal, and it can take days, weeks, however much time you want to spend. It can be a lot of work, and then when you're finished, you're greeted with like 100 or 200 pages of this legal document, the PPM, and I try my best personally to read that document line by line, word by word. But I'm wondering, is there a Cliff Notes version? Is there some way that you can sort of focus in on a few things that you just absolutely cannot miss, and then maybe the rest is just kind of legal jargon?
So all of that is exactly right. And the short answer is yes, there is. And for some of you who have reviewed more than, a couple of PPMs, start to see some consistency in them. Of course, first really is your risk factors, conflicts of interest. I think it's important to understand the context of the PPM and sort of its purpose. It's really a disclosure document, and disclaimers under a 506B offering, it's required. And so that's why much of it looks boilerplate, which is, of course, just rinse and repeat legal terms that have withstood the test of time and litigation. Okay. And it is important to read those. And when you sign on, to the operating agreement and you fill out your subscription documents, you're taking, or making your investment subject to all of those risk factors. So it's one of those. The legal theory is really estoppel. You can't sign on to something and set up a defense, pursuant to that on the back end, right? So just read the risk factors and look at them, and they mean something. Now it's not, it's not an opportunity to get paranoid about the deal, but it's important that you read those at least in your first PPM. And then if you get, on a deal by deal basis, there may be, different elements to the deal specifically that, that may be addressed in those risk factors. So it's important to, to be scrupulous and to pay attention to those. I can tell you as a passive and active investor myself, I look at the distribution waterfall. I look at management fees. Number one, you want to know, okay, I think maybe primarily, what's the initial capital contribution minimum? Do I even meet, the minimum requirement here to invest here? As we're probably all accustomed, market is generally 50,000. Some people like to lower that threshold to bring the opportunity to a wider audience, and that's fine. Some increase it. Typically, the higher you see the minimum, more often folks are more comfortable doing a 506C because they're going to go after a specific group of individuals, all of whom are accredited, because they're the only ones that could afford the minimum. After that, you want to get a hold of their pro forma. Particularly in a 506B, it's required that they provide the financials and the pro forma. Okay, and look and see what are they indicating that I'm to expect here on my distribution, and look at that, and then go compare it to the distribution that's going to be number one. Remember, everything that's contained in the PPM is actually a summary of the operating agreement. Okay, so if you're looking at technical terms about the operation of the property and other things, it's just a summary of the operating agreement. And remember, you're signing a counter signature page to the operating agreement, so you need to go back and check that information from the PPM against what's in the OA, because at the end of the day, they're going to hold your feet to the OA fire, or in different contexts, the company's feet to the OA fire. Okay, and so if the PPM contemplates that you're going to have a 7% preferred return, a 70-30 split, and then, hurdles at 12, 15, 18 IRR, look at that and just, be inquisitive of your operators and ask, okay, well, I see here we have a 5-year pro forma and we're anticipating a 5-year hold period. How are these distributions coming along such that I'm going to get my 2x multiple that you've contemplated I get? Now, everybody should understand that 9 out of 10 deals you're making, not 9.9 out of 10 deals, generally you're making your biggest money through sale or refinance. So you're not absolutely killing it from cash flow. That's going to go to service the pref and help bolster your ROI. But just see what they've contemplated, because when you have a hurdle like a 12 and 15 and 18, when the splits are then going to go more in the favor of the manager, right? So if we start at 70-30 and then 60-40s at 12, 50-50s at 15 or 18, you're generally going to get that in your cash out proceeds from refinance, or you're going to get it, on a sale. And just check all that and ask questions like, hey, when do we anticipate this? And if your operator's like, oh, you're going to get all that in cash flow, then that could be a red flag. Like, well, how could you possibly send me cash flow to the extent that I double my money? And maybe it's possible. It would be rare, I think. Heck, you could, if that was my client's deal, I'd probably put in on it if I believed it.
So if I could quickly summarize so far, you're saying risk factors, distributions, the splits, obviously. Is there anything hidden in there that we generally don't look at? I find that a lot of investors will talk to me about things I feel like they're getting kind of caught up in the weeds. They're looking for everything.
Right.
The thing is when we buy a stock or if you buy a cryptocurrency or whatever, you're not really reading any fine print. Whereas this is put big and bold right in front of your face, and it scares people. When really they should at least understand, at least they're getting a certain degree of transparency. And
that's right. That's how it should be. Mm-hmm. That's how it should be for the operators with integrity. You will find some surreptitious things. Those tidbits, are generally going to be found in the operating agreement. But just look at the latitude and discretion that manager has to change the terms of the operating agreement. Mm-hmm. Okay, and if they can do that sort of carte blanche, then perhaps your investment's a little bit more at risk.
Yeah.
Than it otherwise would be.
And capital calls necessarily they shouldn't be required. If they are called, you have the option. But if they are requiring it, then you probably want to turn and run from that deal.
Yeah, particularly if they didn't advertise that on the front end. And I also form private equity funds and some contemplate a capital call. You don't see that very much in an asset-specific commercial real estate deal, because you're not contemplating, typically especially if you have any kind of sophisticated lender, which you have to these days, they've already contemplated your CapEx budget and other renovations that you're going to undertake. So the likelihood that you would actually need to do a capital call in a multifamily investment is frankly quite rare, and would usually crop up if somebody deferred maintenance or there was an uninsured product or something out there and sustained damage or something. But you're exactly right. Mm-hmm. Typically they provide on those items that you have the opportunity. Basically you have the right of first refusal. You can put up the capital and your position won't be diluted. And then if you forego that because you're not obligated, then they could go outside of the company to complete that funding, which could result in a dilution event to you. Also not an ideal or advantageous route. So just, be scrupulous about that operator and maybe even ask if they've ever had to do a subsequent capital contribution, which is in this context, a capital call.
Yeah. Or I've seen, they'll get additional funding, a loan or whatever, and that's going to dilute your investment. So that's all definitely stuff you should be looking at. Is there anything that they can sort of, maybe give it a quick scan, but not necessarily like spend hours reading over?
Yeah. So also look and see whether you can look through the org chart, or you can just look through, a section of the operating agreement. It could be in a risk factor. I've seen it in multiple places. So I apologize that there's not like one, go-to place, for every offering. But understanding whether there's a pref or preferred equity partner in the deal,
Right.
because they'll get paid before the syndicated entity will. So if you need a $10 million raise to complete the transaction, okay, and then 5 million of that is a preferred equity partner, and then the balance of 5 million is your syndication. That first 5 million pref equity partner is going to get their 6 to 8%, five, even see as low as 5 to 8% preferred return, and that's paid out of the available cash before the syndicated entity receives theirs. And so it's just nice to know those things. I would think if you had a pref equity partner in the deal, it would be more comfortable knowing that you have your own preferred return, so that you're getting paid out in these incentives where you're getting some money, I guess, in advance of the manager. And it's just whether the manager is comfortable with that. And again, yes, go to management and authority. Who comprises the manager? Much of the time, you have kind of one point of contact. There should be more than one person listed in a sophisticated multifamily deal, because it takes a team. Anybody who's been in these investments knows that if someone brings you an offering and it's just them and they're going to self-manage the property and other those are obvious red flags. But review those biographies, and to some extent, if you need to double check those or get second opinions on the persons involved, follow up on that. It takes us a long time to earn that money that we're contributing. And so we want to be scrupulous about that, and just know who's got your money. And there's a couple of bigger names out there, and some hosts of other shows and things that talk about, know, like, and trust. And, just make sure you're comfortable with the board and they look like they're experienced. And you can do yourself a huge favor without spending a tremendous amount of time mired down in some of that other boilerplate stuff that I talked about initially.
In terms of, you touched on the capital stack, pref equity. There can be an advantage to pref equity if you're after depreciation, since they're not involved in the debt. Sometimes they're not involved in the depreciation, right? And that can all be contributed to the LP. So you kind of have to weigh what's important to you in a deal. But also, the last guest we had on, he's the real estate CPA, Brandon Hall, and he was talking about something within the operating agreement. This isn't something that we practice, but apparently it can be worded in such a way that the depreciation can be weighted towards the GPs and not toward the LPs. Have you ever heard anything like this? And if so, where should people be looking for that?
Yeah, that's fantastic. Good topic there, Rick. So yeah, absolutely. And again, just some background context, because I want people to understand conceptually how these things come to fruition. But the operating agreement in and of itself is a contract. Okay. And so long as it's not against public policy or against the law, you can contract however you want. It's just an agreement. And just remember the bargaining position between the manager and you as the investor. But you can absolutely allocate the depreciation that's earned by the company to a specific class, and then, of course, proportionately and in other ways. You would look at that, and typically we put it in maybe two different areas. So my operating agreement, it's either in the membership, sort of the description of the membership of the company. In our operating agreements, that's section 4. Excuse me.
Section 4.
And then for me in our operating agreement, and again, there's so many different templates out there. For us also, there's an allocation section, and that's generally going to follow your distribution section.
Okay.
Our distribution section is 5, I think. No, it's 6. But then the allocations is just after that. And so take a look there and see. There's a couple fair reproportions, if you will, of the cost side depreciation credits. That looks like where the LP is in an already tax advantaged vehicle, such that they can't actually capture that depreciation. And so the self-directed IRAs, solo 401ks, and other vehicles that actually don't get to earn that depreciation credit, instead of that loss being forfeited, the manager will just reallocate that to themselves. And a lot of times we'll distinguish our Class A shares from A1s and A2s. A1s are, your typical cash brokerage, cash wire accounts, and then A2s would be these units that are restricted from that from the tax incentives, and then the percentage that would otherwise flow to them go to the manager, and they're assigned in full to the manager there. So no other LPs are disproportionately impacted, but those who can't receive it, instead of it being forfeited, they're allocated to the manager, and I think it's fair.
Mm-hmm. All right, well, something
that.
to definitely keep your eye on. I hate to put you on the spot, but I
That's why I'm here.
for the most part, I don't think people hire an attorney to look over a PPM. Um, do you think that's a worthy? I mean, considering they're investing
Right.
50,000, 100,000, um, if if you think it is a good idea, what are people looking at in terms of what it would cost to have an attorney look over? I guess it depends on their hourly rate. Hmm?
Yeah, it would. I mean, some people flat fee that stuff because it may not take you an hour. I mean, look, if you pay somebody by the hour and it takes them more than an hour, I don't know if they know what they were reading.
Okay,
Um,
that's good to know.
I mean, to your point, Rick, I mean, if someone were, and I haven't done a PPM review for an investor in quite some time, and it's not that I wouldn't. Um, I think, again, to your point, I don't think enough investors do. I feel like my phone, frankly, should ring more than it does with investors saying that. But there's also sort of that complex, that I think LPs and investors have. They're like, I don't want to call this attorney because, number one, I don't know how much it costs. I don't want to pay somebody $2,500 to read my PPM for me. But I think in the past I've charged anywhere from $300 to $500 for the review and discussion on it. My rate these days is $445. And I would recommend it certainly for your first or second offering, and
Right.
then especially if it's a higher risk and a higher turnout. And then if there's any sort of dynamic where it's like, oh, I get these extra special share class, or they want to put me on GP, and I have some of my capital's at risk and stuff like that, call me on those, or shoot me an email, have me review, the documents, and give you that peace of mind. And that's not, and you can't always catch everything, in that context either. I've actually reviewed stuff, talked to the client about it, talked about the implications, the risks and the prospective rewards, and what to, and kind of how to proceed. And he ended up, making the decision on his own that he was going to put in, and then it didn't pan out for him with the particular operator, and it's like, and lost lost money. And it wasn't. And the problem is that you can't really prepare for somebody's real incompetence. But ultimately, I prepare advice for my clients. I talk about the implications of certain conduct. Again, the know, like, and trust factor, and then ultimately you have to determine if it's right for you. I can't
Yeah.
say yes or no, and that's not really my place. It's just to give you an understanding of what you're reading and the implications of any course of action, and then you choose that.
Yeah.
We were so much better off with that client who ended up kind of getting taken advantage of. Even what we did for him, never, because you never contemplate fraud. You just you hope for the best and prepare for the worst. But fraud is one of those difficult things because of the deception component of it. But
Yeah.
even still, he was better off having worked together with me than he would have been on his own, because I think he would have gotten his entire nest egg taken. And in this context, he only lost a little bit of it. So
I
that's
like I like the fact also that you're an investor. Also, like, you invest passively, like you said. You kind of understand the structure. So if someone comes to you and they talk to you, I think if they're like, freaked out, you're gonna talk them off the edge of the cliff. Also, like, I wouldn't worry so much about that. I mean, you have to, just like the deal itself. I got a deal the other day. I invest passively on the side out of my 401k. I got a deal and it was looking pretty good. I was like, wow, these are quite healthy returns. But then I understood that they had not baked in a forward curve into their underwriting. So in other words, they weren't projecting out the interest rates 3, 4, 5 years from now into their underwriting. And if you look at the, I don't know, like the SOFR forward curve, for instance,
Yep.
2, 3 years out, that's an additional 1.4% on top of what we have today. So you're talking 4.75% in 3 years. And this person also, or this operator, involved a refinance into the underwriting, which is, in my mind, it's a no-no, because you just can't predict the future, right? We don't know what interest rates are going to be 3 years from now.
Yeah, but it
But
would be advantageous to do that. Exactly.
he did, and he had predicted that they're going to be 3.5% 3 years from now. They're going to do a refinance, and they're going to get an interest rate of 3.5%. That's that's highly unlikely.
Optimistic.
I mean, these curves, they're not set in stone. Doesn't mean interest rates will be 4.75%, but you want to look under the hood and make sure that it's at least underwritten that way. So
And conservative, right? And I think the conservative approach is to contemplate that increase and to hold things constant. I think is an ambitious, method of underwriting. And ultimately, as the manager, you're subject to that. And I tell my clients all the time, look, you can make certain representations and things, but sort of give yourself the latitude and discretion and advertise that, hey, things may change. Here's what we're prospectively doing over the next X number of years. But ultimately, if we need to shuck and jive and adjust along the way, you have the latitude to do that, short of adversely impacting your investors, contributions in equity and other things.
yeah,
And it sounds to me like, someone who's I don't know whether you explored that opportunity further in things, but that was very scrupulous of you to be able to recognize that. And that's why it's great to just have that business acumen as well as you're reading some of these documents. And while I love my clients and so many people getting together in these group thinks and working through documents and going through boot camps, I spoke at one just a couple of weeks ago where you're getting in there and you're learning things like you just shared, Rick, that could be the difference maker between perhaps putting in that investment and recognizing that if this operator can't really do the underwriting well, do I have supreme confidence that they'll be able to operate the property well? And so, I would perceive that as a possible red flag, depending on the context of everything else.
Nicholas, I like so many questions I want to ask, but I don't want to tie up all the time. People came on tonight, and I promised that they could answer, or they could ask their questions. I have a few that are written in, but those that are on the call, if you feel like you just want to unmute yourself and ask, you can do it that way. Otherwise, if you'd rather put it in the chat, we can do it that way. Do a little Q&A right now, and if there's time, I know you have a hard out, but if there's time at the end, I'll ask. I had some questions about joint ventures, and for those active investors that are on the call. But
Rick, this is Guido. I can ask a question.
right on, Guido. Start it off,
man.
Hey, Nick, how are you?
Great.
Guido is the guy that I set up with Nick. So
Yeah, so we know each other. my microphone went dead, so hopefully this subbing microphone is working.
Yeah, loud and clear.
Question on joint ventures when there's equal partners and all the partners have the same number of shares. When there's significant decisions like the sale of an asset, how do you break an impasse?
So that's going to be great question, Guido. And I've got some documents headed your way tomorrow. So let's follow up on that stuff. Right. Great question. So typically not typically, it's advisable to get into, in with an attorney in a law firm that specializes particularly in multifamily. Of course, in a self-serving way, our firm, can help. So that it contemplates, the operation and complexities involved in multifamily real estate. Okay, and so our standard form agreements have sections that speak directly on this. All right, and typically they're boiled down to what we call major decisions. There's certain businesses and activities that can be undertaken. If you're joint venture, there's two different designs of joint ventures. One, of course, is manager managed, okay, and the second would be a member managed. Member managed is where, in your example, Guido, you would have, let's say, three partners. Everybody's equal. You guys quarterback by committee. You all make the decision together, et cetera. Okay, and then perhaps you nominate just to consolidate the responsibility of signing things and undertaking certain things. Typically, you consolidate that authority into one person in the operating agreement. But it would say, here's how we handle taking on debt more than $10,000. We need two-thirds. All right, so one person can be like, I don't want to take that on, but two people do. All right, then you could say, all right, for a sale or refinance of the company, we need unanimous. Okay, so we need all three of us to agree that we're ready to sell this property or to refinance this property or some other major decision that you stipulate. Addition of another member, that's another major decision. Again, debt thresholds, sales, substantial sales, any sort of dilution event, things of that nature. You find a higher threshold for undertaking those. But have your operating agreement speak to that generally or specifically. Now, if you don't have the benefit of an operating agreement that speaks specifically, then it's a general partnership and majority wins. And so, but it actually, I say that it depends on the state that you're in. Okay, that's actually a matter of state law. So just so you know, a little bit of context. Your operating agreement controls those matters on which it speaks. And your statutory law governing LLCs in this case, or corporations, whatever structure you're in, speaks on those items that the operating agreement or articles or bylaws do not. Okay. And so as what happens in business litigation a lot, and I have some experience in that in my background, this is the stuff that comes to light. And then you bring up an operating agreement, or heaven forbid, there's not one. And now you're talking about, it's a true general partnership that's going to be in the statutes, and it can just get ugly. So it's better earlier than later. Have those tougher conversations on the front end. It's all fun and games until you start making money, and then people don't want to agree on certain things, and just have the ability to put those decisions in there. You need to have also, sorry, this is a long answer. It's just a lot, right?
You're taking notes, right, Guido? You're getting this word for word.
He's got the recording. He's gonna listen to it on the way to work.
This is being recorded, folks. So.
Yeah. I got my train of thought lost. But ultimately, just get the operating agreement going. Be intentional about it. You don't want to miss the opportunity to prepare for these things on the front end. Okay. Otherwise, again, you're left to just statutory law, and that doesn't help anybody. Okay.
What type of significant events, other than a sale, should you list in an operating agreement that requires majority vote or unanimous? Like what kind of event?
So like I said, so debts, and then you figure out the threshold. If you want to have full sign off for anybody to take more than $1,000, you can do that. $500, $10,000, whatever that threshold is. And you'll find that the less time and experience you have with partners, typically the lower that threshold is.
Okay.
Right. Ultimately, I've noticed in more of my sophisticated operators, they move more to a manager-managed dynamic. And the reason being is one person has clearly demonstrated trust, competency, ability among the group so they can undertake the daily stuff. And then all those things that are just not daily. Like, we don't sell daily. We don't sell the whole company daily, right? That's a major decision. We don't take on debts of X number of dollars on a daily basis, put that in the bucket. We don't refinance on a daily basis. We don't admit additional members and some of those other things.
Like that.
And that's why you lean on your practitioner to be able to provide those things, because I've seen a lot more, of the contentious dynamics than others have. And so we've worked those items. I mean, I've modified my operating agreements and other things to provide for random circumstances that my clients have experienced.
Got it.
And always my goal is for you to avoid litigation and avoid having to hash it out. Finally, I talked enough that I reminded myself where I was going a minute ago. And a buy-sell agreement is also important. Okay. So of course you can always mutually agree on things, but sometimes you might get to such an impasse that you can exercise a buy-sell agreement. And there's a couple of fun things that you can do in there. And I say fun, sort of joke, tongue in cheek, because it's not fun for anybody if it gets there. But there's kind of this roulette one that I try to go to a lot, which is, I can offer you a price for your shares, and I pay you in a faster amount of time, but you have the option to actually buy me out and pay me at a slower pace, so that you're not, lowballing offers and other things, and you only exercise it when it's absolutely necessary. So buy sell agreement, major decisions, daily responsibilities, and delineating those things as best you can is going to keep your partnership really healthy. Think of it as it's your constitution for your business.
Yeah, I like the frame of thought where it's the hurdle is it a daily decision versus like a yearly or within some sort of time frame, and that's how you split the buckets. That makes a lot of sense.
Yeah, and I actually I'm glad that resonated, because I just made that up right on the spot. But it holds, right? It's one of those things. It's, hey, this is special. This isn't something. This isn't me picking the maintenance crew that's going to come, clean this up, or what bank we're going to go with, or some of these other things. And so with that, thinking about it in that context, it's true, and can be helpful.
Got it. Thank you.
Joe Villegas got a question. I'm wondering if he wants to ask it. Or you want me? If I should just read it, Joe.
Well, I'm happy to ask the question. Can you hear me okay?
Yeah, go for it, man.
All right, cool. So I've read like a handful of PPMs and still relatively new to this, but as it pertains to distributions, I've noticed that there's a marked difference between various syndicators in terms of how the split after the pref is met is handled. Mm-hmm. And in some, there's no mention of a return on investment versus a return of investment. However, some will delineate that. And as soon, in some PPMs, it'll indicate that as soon as the pref is met, over time, that any additional profits will be a return of investment. Like, now, my only thought there is that any invested capital would be returned at a particular rate over time. And so in terms of any like planned cash flow for an investor, that would reduce over time, since the now initial capital outlay is reduced based off of that return of investment. But it's not always like clearly defined as how that's going to be handled, what the intent is, because some managers will have the authority of how that's handled over time and leave it up to management, which is fine. But you can talk to a syndicator and they'll verbally tell you what they intend to do, but it's not written in the PPM. Do you have any recommendations or suggestions of how an investor should interpret that, and how that should be, I guess, portioned into their risk analysis of whether an investment makes sense or not?
Yeah, for sure. Great, thoughtful question. Yeah, I mean, I experience this regularly. We delineate in our agreements between return on and return of, particularly in a pref context. And in a straight common situation, it's less of an impact, because to your point, your pref is actually calculated on your capital account balance generally, and that's why they try to qualify that maybe it's non-compounding, annual, non-cumulative, or excuse me, cumulative non-compounding, preferred return based on your initial capital contribution. If they can, if it doesn't speak on it at all, that's a concern and something that you would want to ask. And remember, it's not just getting an explanation, it's them putting it in writing. And you have enough influence, I think, to get that in writing. And particularly if one investor recognizes that, others may have as well. And so it'd be something, I think, worth your time to follow up on. But ultimately, you don't see too many operators. I mean, unless they're just, you're good, upstanding. And I've just been so blessed to have just great clients with high integrity. I'm a man of faith. I'm not going to prepare any documents where there's some sort of deceit or something, that could be deployed. That's just there's just no time for that. And so ultimately, you would look at it. Typically, you're going to see the return of capital at your capital event, right? And your refinance, and then at your sale. And it should be near the top of the waterfall that your initial capital contribution is returned. Generally, you're not seeing in more sophisticated documents, you're not going to find a return of capital during the cash flowing operation of the business, because there's just not enough there. But absolutely, if you're looking at an investment that has a preferred return, you want to ensure that your initial capital contribution is preserved, or that that your pref is calculated on your initial capital contribution, irrespective of your capital account, so that that if you put in $100,000, you get $7,000 per year in a 7 pref, paid quarterly, monthly, whatever the case may be. But in our documents, generally what happens is you have, of course, the sale, and then you have all the expenses associated with the sale, or in the case, refinance. Then from there, the net proceeds are generally going to go to cash out. Well, it goes, if you have a pref, it's going to go catch up any unpaid preferred return. Then it's going to pay the current preferred return. Then it's the return of initial capital contributions. Okay. And then the net proceeds from there are going to be pro rata based on your units. Okay. Or your membership interest percentage. Anything other than that is not, there's a couple of different scenarios in there, and that can exist, but that's generally, to speak to the larger audience, that's generally what you're going to find. So just be scrupulous about that. If they don't have it in there, I think you make it a condition to making your investment. If they're going to have a high pref and no common equity, and perhaps it's just a preferred return, then it's absolutely imperative that they have it in there, because they're going to predicate that pref on that capital account. So you don't want to be getting cash, thinking you're getting cash, when really they're just returning your capital contribution, and now they owe you 7% on 50K instead of 7% on 100. So make it a condition to your investment, and that'll keep you safe. And if they're not willing to put that in writing, then maybe that tells you what you needed to know about that operator.
Yeah, Nick, that makes a lot of sense. So when you say put it in writing, is an email sufficient, or is there another mechanism required?
There's another. It's called the operating agreement. So this isn't a side letter. If they're not willing to put in an operating agreement, you could get a side letter from them that would indicate that your particular investment is safe from a return of capital before a capital event or something like that. I've never done one of those on behalf of an investor, on behalf of an operator, where we were trying to return the capital early. I do have a client now that reached out, and so here's another one. Okay. So short answer is, get in the operating agreement. Secondarily, if they won't do that for everybody, then try to get a side letter. If they won't do that, then that might answer your question. But I do have a client, and again, I do a lot of private equity fund work as well. So it's not just specific to multifamily, but I have had clients that are like, hey, when the people give us their $100,000, we base our returns on returning the $100,000 to them first. Like, hey, we're going to actually give you your initial capital contribution back, but here's how the metrics will be on the balance of that money. Okay. And so they are getting their money back. It's not really a return yet, because they wanted to promise their investors at least their money back before the manager really starts to take income. And then after that, they continue to split the proceeds on a 70-30, or whatever the case may be. So there are limited circumstances, but generally for your income producing commercial real estate, single asset syndication stuff, you need to have it in writing, express about how the capital is returned. Otherwise, if the authority is there to determine, the manager can determine when it is, seek clarification on that. If it doesn't speak on it at all, then generally, if the waterfall doesn't provide the return of the capital contribution, any capital to you is deemed to be a return on your investment, not a return of your capital. Okay, so the default is that it's cash returns, but that could conceivably vary from state to state. I don't know all the states' laws to know that. And again, that would be how that's handled in the state in which the really where the investment is and where the property is going to control. Sometimes they put it in Delaware, other states. So just, be scrupulous about that, so you're not kind of chasing your tail on this kind of stuff while your $100,000 is at risk.
All right, Nick, I'm gonna move along because I want everybody to get their questions in to have them. I see that Chikazi, am I saying that right? I hope
Yep, you got that right. Sorry for the background noise.
No worries. Ask your question.
Gotcha. Nick, I actually had a chance to meet you at the at Michael Blunt's boot camp a couple of weeks ago.
In the lobby?
Yeah, in the lobby, yeah. As we were checking
right
out.
at checkout? Yeah, man, I appreciate
appreciate
your kind words, man. I enjoyed talking to you and talking to the group.
For sure. So another quick question. What are some of the safeguards that you guys put in place to kind of mitigate some of the some of the sellers from putting in less than ideal tenants, I guess like within that closing time period? So let's say you find a deal, but then you notice some of the leases are expiring within the next 2 to 3 months. What are some of the safeguards that you all kind of put in place into the contract to kind of protect against that?
Yeah, so great question. So typically that is a standard paragraph in my agreements that provides for, typically you'll find it under the operation of the property paragraph. And what you're stating is any leases that come in, they have to be obtained in the ordinary course as they always have done. You could get as granular as you want, because remember, it's a contract, and you could stipulate, hey, we're not going to do any more low income housing because the lender doesn't want it. If you need to specify that, the best that you can do is say that any leases after this point have to be approved by you. I've noticed that on shorter timelines,
okay,
you're going to have the contract period for like 90 days. A lot of times they push back on that. But if you can get, contract 60, 75 days, 60 is really market now, you guys, 30-day inspection, 30-day to close. You can go in there and try and give yourself the authority to accept or reject a tenant. And then you can also limit the lease time. So it has to be a minimum of 6 months, but can't be more than a year. They can't rent for less than 5% under, the going lease rate and other things there. But we provide for that. And that's a great question and something you definitely want to prepare for, because some people, and then make sure you get your leases in writing, do your closing walkthroughs and other things just to confirm that, those bodies are actually in there and it doesn't end up harming your economic occupancy, particularly if you're under agency debt and other things. So good stuff.
All right, cool.
Thank you.
Gonzalo, did you have a question? I thought you had some stuff. If not, we can move to the next person. If you have a question.
I do, Nick. Rick?
All right, yeah.
Can you hear me?
Yep, go for it.
Hey, Nick, thank you very much for speaking on this. I have a situation that we've been kind of dealing with the last couple of years on an investment, and we're currently now in the process of trying to remove the GPs, the operators, on this deal. It's a small multifamily investment we did a couple of years back.
Okay.
Yes, exactly. We've been pretty much managing this investment for the last 2 years. So now we're kind of we're going through the core process. Based on your experience, if you've, went through anything like that with past clients, and how successful were you?
So I haven't, fortunately, but I have a pretty robust litigation background. It really does depend on how the terms of the operating agreement are provided. Much of the time, and this is great. This is actually a great question because it dovetails into PPMs and operating agreements. But it's removal of manager. Okay, and you need to pay particular attention to that, because most of the time the manager is going to require that a court of competent jurisdiction, okay, meaning the proper court, has adjudicated that you are incompetent, unfit, incapacitated, or whatever other factor exists such that you're not permitted to operate that property anymore. They'll give the takeover rights, to the people who can take over. That might be the members. It could be other Class B members, whatever the case may be. You're demonstrating just something greater than probably negligence on a consistent basis could rise to the level of removal. If they're just kind of careless, or they're just not great business persons, there may be nothing that you can do, and a court may say, yeah, this is bad business, but they haven't done anything. They're just bad business persons. And I know that sounds like, well, there's got to be something there that we can, sink our teeth in or stick our hooks in. But
something fraudulent, right? Something
yeah,
fraudulent.
I
Those
mean,
bad boy carve-outs.
Well, there's certainly bad boy carve-outs, where you have the cyan or the intentionality behind it. You're siphoning funds, you're embezzling, and you're doing other things of that nature. If you're just bad and you're not leasing the property up and other things, if you're showing that you're unscrupulous and you do sort of and you take it to the courts, you're just going to compile your evidence to show their unfitness to manage the LLC. And it's really an administrative action against that manager to remove them and then appoint, generally in accordance with the operating agreement if it speaks on it, and then in accordance with state law if it doesn't. And so that could fall down either way, Gonzalo. Just build up your evidence on negligence, and you can show rents in the area and other things that could be leasing up and other things. But this is also why you really just want to get with some folks you trust, because unfortunately Gonzalo's experienced that even though this industry feels like it's fail safe, not everything's a home run.
Does that answer your question?
Yeah, I completely agree. I mean, this was a couple of years back. Yeah, thank you. I appreciate that, Nick.
Yeah, but follow up with me if you'd like, and we could chat a little bit further about that offline in the coming days and weeks if you need someone to be a soundboard.
I'll definitely.
Will do. Thank you.
Yeah, again, Nick's info, our info is at the top of the chat box. So make sure you click on those three dots and save chat. Then you can have that for future reference. Anybody else want to go live? You can raise your hand by clicking that reaction down there and it'll say raise hand. If not, we can read some of these in the oh, we got one. V, am I saying that right? Is it V or Vi? V.
Yeah, it's V. How you doing today?
Hey V, thanks man.
Hey, sorry about that. Thank you so much for you guys doing this. I'm kind of a newbie at all this. I did go in on a recent private equity real estate fund recently. I'm just trying to get an idea about, hypothetically speaking, if this is kind of a good deal or not. In essence, obviously I know this is not, professional advice or anything like that, and I consult my own attorney and all that. But so in essence, the deal is the fund is towards a large multifamily deal with small multifamilies with that, multiple single-family homes. Has no waterfall, no pref, no catch-up pref, no acquisition, asset management fees, or capital event or disposition fees as well. In essence, this is like a 50-50 split after the LP gets the initial return of capital within a 3 to 5 year period. It's essentially, the expectation is like there's limited cash flow within the first initial value add period within the first couple of years. But, their plan is to essentially utilize a lot of cost segregation, bonus depreciation, and then cash out refinancing with the indefinite hold period. They're kind of anticipating about a 15 to 20% return annually, or like what they said was more like a 50% annualized rate of return, but they weren't using like a into a rate of return for the cash. But I'm kind of new at this. I'm sorry if I sound a little bit confusing in a way trying to describe it, but I'm just trying to get a general idea if this was a relatively good deal, or did I kind of get myself stuck in a situation? It was essentially 100 shares, $10 million total fund, essentially.
Okay, well, some of those numbers. I mean, look, here's the thing. So I really, you gave me, you kind of gave me the ingredients, but I don't know what you made. So here's how it works, right? So you need to, if it's more of a wager if you don't know what you're doing. Some of those numbers sounded market and some of them didn't. A 50% return year over year. I mean, I guess in value add, you could do that in a class C or something, and you're taking 150 units, and maybe you're not cash flowing because you got a huge construction budget and other things, or you're just you're going to go in and completely gut the place out and get rid of all your tenants and then rebuild it and sell it for X number of dollars down the road, and that boost in equity is going to be on the back end. the fact that they're not doing disposition fees, asset management fees, acquisition fees, whatever fees they're doing is fine. They're just trying to make it look more appealing to the investor, because they're just saying, hey, we're not going to take any money because we know we're not giving you any money, is what I heard, right? Like, you're not going to get any money, but, well, don't worry about us. We're not taking any either in the form of these fees. That didn't sound like market for much of the offerings that I do, but I mean, I see stuff all the time that it could be good. Look, this is when you need to go look at that board and ask them questions and understand their background, their experience. Have they been through the same process with value add? Have they done an exit? Have they performed full cycle to the extent that they know what to do in the beginning, the middle, and the end? To Rick's point, he had somebody do some underwriting, forecasting interest rates that would probably tell you that person has never done that before, because generally, with the exception of the Trump administration, a little bit of the Obama administration, interest rates do fluctuate quite a bit to try and stave off inflation and other economic factors and things. Okay, so just look at that. Make sure that you feel comfortable with it. That's a decision only you can make. But the more coaching you can get and the more material you can read to let you determine whether or not that is an investment suitable for you is up to you. Because I can tell you, when they give you the documents, you're going to disclose that you've reviewed the offering in its entirety and that you accept the risk, including the entire risk of loss, of your entire investment, and so that falls with you. Okay.
Right. But thank you so much for the feedback. Yeah, they were pretty much saying that we're going to get our whole capital back. We were the primary one that we would get our capital back before the GPs get anything, essentially.
Well, that's better, but that doesn't make the deal, because you're still betting on them to be able to perform in accordance with something they may or may not have done before. Just follow up on their performance history, and if it checks out and they kill it and they've gone full cycle on a couple of these, then you can invest with greater confidence. Maybe not complete confidence, but greater confidence. But some of those metrics would have to require a value add. And if you're okay not cash flowing your 50, 100,000, 500,000, whatever it is, for 3 years while they're swinging hammers, then go for it.
Right. Just one last question. Sorry if I'm taking too much time, but if I invested as an individual versus through a self-directed IRA or whatever it might be, is that any kind of major issues with that in a private equity real estate fund like that?
No, you're passive at that point. There's no exposure to you from liability, which is generally why I advise investing in an LLC. You could do it personally. It's entirely up to you. Ultimately, the depreciation flows down to you as the warm body on your return and can offset other income. But work with your CPA on that. Those are CPA questions specifically. I've got great working knowledge, but I can have the exact answer, but I always want you to check that against your CPA.
Much appreciated. Thank you so much.
Yep. Thanks.
Hey, I have to read this one. This is from Vids. He couldn't make it, really wanted to make it. Can you see that in the chat box? Because it's quite specific. My HOA has become highly litigious. A small set of owners who have disputes between themselves are suing each other over and over, and somehow they always add HOA board and management company into filing.
Which one are you on? I'm seeing
I want you to
an
read.
8:09 p.m. Joe one. Which one are you on?
Go all the way to the top at 4:52. It's from me, but I just copy and pasted his question.
The earliest one I see, and I could be doing this wrong, is 8:09 p.m. from Joe. To everyone.
Okay. Yeah.
You want to re-put it? You want to repaste it into the chat box if you can?
Yeah, let's do that.
Do that, and I'll give it a quick perusal.
See that?
Yep. Let me read this real quick. So this is, unfortunately, this is somewhat oblique to my practice. I don't really deal with HOAs, because if this is a condo context, just so everybody knows, you can have a condo and convert it to multifamily. There can be a condo regime, and typically we try to terminate those. I mean, you'd have to get into one of these actions, and it's probably going to be a declaratory action, unless you sustain some kind of damage. But you'd be looking for a declaratory action because you, in effect, would be looking for the court to render, a ruling on, the rights of a certain party, and then that's dispositive of that issue. That's how that works kind of globally. But this is a little bit, there's not enough facts with the complexity of what we're talking about here for me to really weigh in on that. And I certainly haven't seen this in like a multifamily or commercial real estate context.
Okay. Yeah, I figured. Yeah. I wanted to touch on the JV thing. I see a lot of discussions up on Bigger Pockets, where people say, as long as they provide the sweat equity, they can bring in people as just the silent money partner, and that is definitely not the case, right? I mean, everybody equally involved in a joint venture must be actively involved. That's correct, right?
Exactly right. That's exactly right.
So if someone is looking into bringing in just a money partner, what's the way around that? You bring them on as a private lender with like a promissory note. Is there a way to bring on a silent partner who's just a money partner and not considered, part of the joint venture?
Not really. So you could probably do the promissory note maybe one or two times, and it would just have to be more short term. Generally, there's also debt securities in addition to equity securities, and this would be a debt security. So if you continually and routinely lend money, borrow money in this context, then you're prospecting that money for them to pay them a return in interest on that note. And so that could be deemed a security. In the equity contents, the SEC has been clear that a security really is just a profit earned on somebody else's effort, right? And so you either have to register that security or you have to qualify for an exemption. And the way we qualify for the exemption is the offering through a 506B or 506C. There's other mechanisms that you can use, but those are the two by far predominant methods for exemption. So look, you either tell them, hey, you do have to be involved to some extent. That doesn't mean you have to be out here boots on the ground every day, but you do have to be involved in major decisions and some other voting things as it pertains to the company. Alternatively, you can help pay for the cost of hiring a guy like me to put together all of the exemption documents for you. That's your alternative. But if you bring somebody on and they are indeed passive, but you have not registered that security, then you would be contravening the Securities Act of 1933.
Gotcha. Hey, I've shared my screen here. Can you see that? Can you?
I can't.
Is anybody seeing? There's should be a slide up that shows our contact info. No?
Yeah, we can see it.
Okay, good. Just take a screenshot, folks, if you need to contact either one of us. Like I say, I'm always open to conversation if you just want to talk shop. Just copy and paste that, or at least write down that Calendly link. And Nick, can't thank you enough. This has been awesome. I know you're going to have to run out of here pretty soon. I want to make sure everybody get their questions in. I don't see anybody raising their hand. I don't see anything new in the chat box. Going once, going twice.
Just me thanking everybody.
I see a new message.
It's me. Me saying thanks to the group. These hours, just so you know, this is not, these opportunities aren't taken lightly. The fact that you guys took an hour out of your day to spend it here to listen to the things that I was able to share today means a lot to me. I appreciate that very much, and hopefully you found it informative. And certainly follow up and let's let me join your journey and help you out. And Rick, this has been a distinct pleasure, man, and hopefully it's the first of a few. So I appreciate you very much. We could start our own podcast, the two bald small guys.
Let's do it again. I kind of like that we just kind of kept it conversational as opposed to the PowerPoint. And I do hope everybody got their questions in. And like Nick says, you can follow up with him. And he stole my thunder a bit. I also want to say just thanks for coming out. I know it's dinner time for a lot of people. Other people are getting their kids ready for bed, whatnot. So appreciate you getting on and showing up and participating. So thanks, guys. We'll do it again very soon. Good night, y'all.
All right. Thanks.
Thank you, Rick.
See you
All
guys.
right, thanks, guys.
Thanks, Nick.
You're all. You're
Have a
welcome.
good night.
Thanks, Rick.
You're welcome, guys.
Thanks,
Thank you.
everyone.